Thank you, Mr. Chairman, members of the Commission. It is an honor to be there, and I am grateful for this opportunity to be heard. I stand here today on behalf of more than 700,000 citizen ratepayers in South Carolina, and it is our position that the unconstitutional application of the Baseload Review Act has deprived these ratepayers of their right to be adequately heard on the numerous rate increases they have incurred over the last 10 years. I am here today to be their voice. While I must briefly discuss the history of how we got to this point, it is not my intent to rehash or relive or even relitigate the facts that brought us here. I'm concerned primarily with the ratepayers and how we're going to treat them going forward from this point in time. It is imperative that the ratepayers' interest as well as the public interest be adequately represented. Before I would begin, I would like to say that I believe that every party that is here today is here in good faith and with good intentions, and I personally have good friends on both sides of this issue. And I'm not here to assign blame. However, the facts are what they are. A law was passed, a construction project began. This law funded this construction project through a statutory process. That process allowed utility rates to be raised 9 times over a decade. The ratepayers had very little say in those subsequent rate increases. The construction project was then abandoned. Ratepayers have now spent billions in higher rates, but have no nuclear facility to show for it. Basically, more than 700,000 ratepayers were forced to buy a money pit, and they were not given adequate input into that decision.
Amen.
All of us here today have the ability to be a voice for the ratepayer by constitutionally applying the laws of this state in a way that affords all parties the due process that they are entitled to. I would like to address several questions. The first question, what can this commission do? I'm here today because this commission has within its power the ability to right the ship and protect the ratepayers going forward. This commission possesses the power under our Constitution and existing Supreme Court precedent to determine if ratepayers' constitutional rights were violated. We have extensively discussed these precedents in our brief. Contrary to what SCE&G argues, our state Supreme Court in the Ward case has said an agency or ALJ can still rule on whether a party's constitutional rights have been violated. It is our contention that the ratepayer rights have been violated, and you have the authority to rule on this. Another, and probably the question I would pose next, why is the Baseload Review Act unconstitutional as applied? The Baseload Review Act requires ratepayers to pay now and hope the plant is finished later, leaving ratepayers holding the bag. Under this act, after the initial rate increase, all subsequent increases lacked notice and an adequate chance to be heard by the ratepayer, who is an equal stakeholder in this process. This violates both the state and the U.S. constitutions in several ways. First, we believe due process is lacking in the Act, particularly in the proceedings laid out in Section 5833-280. Under the Baseload Review Act, the initial baseload review order is made final and binding for all time. As Justice Hearn emphasized in the 2010 Energy Users decision by the Supreme Court, she said, there is no mechanism in place to challenge the prudence of SCE&G's financial decisions. In the Porter case, our South Carolina Supreme Court said ratepayers have a right to notice and an opportunity to be heard. In this case, the ratepayers had no voice under the Act other than the submission of written comments, which is woefully inadequate for due process purposes. This violates Article 1, Section 22 of the state constitution, which says, no person shall be finally bound by a judicial or quasi-judicial decision of an administrative agency affecting private rights except on due notice and an opportunity to be heard. Furthermore, the court in Porter concluded that the notice given in several newspaper publications was not sufficient for due process purposes under Article 1, Section 22. In this current matter, SCE&G says in its brief that it gave notice in 5 newspapers of upcoming revised rate increases, and that customers could file comments on those increases. SCE&G then says after the rates were increased, it then notified its ratepayers through an insert in each bill mailed out. Basically, ratepayers were given insufficient notice that their rates were going to be increased and only given sufficient notice through bill inserts that their rates had already been increased. Now, I'm not trying to be flippant or cute, and this is probably ridiculous analogy to make, but some in our office have made this analogy, that it would be analogous to a defendant being notified about their criminal trial through a newspaper ad and then being told they could only argue their case through written comments. Then after the trial, the defendant could avail himself of all due process protections. It would be laughable to assert that due process only applies after the trial is over. Finally, on this point, SCE&G has argued that ratepayers don't have property rights to their hard-earned money. But the South Carolina Supreme Court in the Porter case has held that customers have a right to notice and an opportunity to be heard before their rates are raised. SCE&G has said that written comments by customers are sufficient due process before a rate increase occurs. But the U.S. Supreme Court has held that written comments are inadequate due process for welfare recipients. Surely, the ratepayers in this case are entitled to the same protections as welfare recipients were in that case. Second, the Base Load Review Act violates the takings clause of both the state and U.S. constitutions. The government cannot take your property for public use without just compensation. By guaranteeing the funding of the nuclear construction project on the front end through rate increases, the Base Load Review Act is authorizing the taking of the ratepayers' money, which is their property, and giving it to SCE&G's private investors, which is not for public use. This act is heavily one-sided in favor of the utility and private investor against the interests of the ratepayer. This lack of balance makes these rates, in our opinion, unjust and unreasonable. As this commission has always said, in order to avoid an unconstitutional taking, it must set just and reasonable rates, and it must balance the interest of the investors with that of consumers and the public interest. Until now, the Base Load Review Act has created a situation where ratepayers have been left with no adequate voice in the rate revision process. Previous commission orders have consistently recognized that the role of the commission is to set just and reasonable rates by balancing the interest of the utility and its investors on one hand with the interests of the ratepayers and the general public in the other hand. The Base Load Review Act ignores this balance. Judges Robert Bork and Ken Starr in the Jersey Central case each concluded that ratepayers cannot be charged exorbitant rates and receive no service in return without there being an unconstitutional taking of ratepayers' property. Judge Starr foreshadowed the Base Load Review Act when he explained that the used and useful rule, which the Base Load Review Act abandons, is a safeguard to protect consumers from paying higher rates and yet receiving no discernible benefit in return. The next point, the Base Load Review Act violates Article 9, Section 1 of the state constitution. As this commission stated in a 2007 order in the Carolina Water Services case, you said, this commission's authority to consider the public interest in the course of a rate case is derived from the state constitution. The South Carolina Constitution provides that the General Assembly shall provide for appropriate regulation of common carriers, publicly owned utilities, and privately owned utilities serving the public as and to the extent required by the public interest. Therefore, all regulation of public utilities must be conducted in a manner consistent with the public interest. The state Supreme Court in the Duke Power case has agreed with your authority to regulate public utilities only in the public interest. However, the Base Load Review Act is not regulation in the public interest as required by the state constitution. It is regulation in the private interest. Intended or not, the Base Load Review Act puts SCE&G's investors first. We cannot place the interest of investors over the interest of more than 700,000 ratepayers. To sum it up, because the Baseload Review Act failed to offer sufficient due process protections or regulate utilities in the public interest, we believe the 9 revised rates are illegal. We are now asking you to address this problem by balancing all interest involved and acting accordingly. You have the authority to grant ORS's rate reduction. This commission has used Section 5827.920 to reduce rates previously. Also, SCE&G is correct in its briefing on one point in its argument. It asserts that the Office of the Attorney General is assaulting the Baseload Review Act, and we agree with the company that there has been an assault. But the assault is not on us on the Baseload Review Act, but the Baseload Review Act on the ratepayers and the rule of law. Finally, no one wants any company, especially SCE&G, to go bankrupt. The public interest is everybody's interest, including SCE&G, and it is best served when the interest of SCE&G's ratepayers, its employees, and even its investors are properly balanced. But that proper balance cannot happen if the law is applied in a way that functionally allows the company to balance its books or pay its investors on the backs of ratepayers. Real people, and I talk to them all the time, they're hurting. They struggle to pay their light and their heating bills from month to month. You have the power to help them, and that is what we are asking you. I thank you for this opportunity to be heard, and I'm happy to answer any questions you may have.